So let's start. So welcome to this session of the Global History and International Law Seminar Series on today, the Indian princely states and the 19th century transformation of the law of nations. To start us off, I'm very pleased to welcome Dr. Prabhakar Singh, Parvati Menon, and Dr. Karl Landauer. So our speaker today is Dr. Prabhakar Singh. He is an associate professor at the GH&IL Global Law School. He studied law at Barcelona and Bhopal and hold a PhD from the National University of Singapore. He co-edited a book entitled Critical International Law, Post-Realism, Post-Colonialism, and Transnationalism, published by 2014 at Oxford University Press. And Prabhakar also wrote many journal articles in Asian, European, and North American reviews. Our first commentator is Dr. Karl Landauer. He is an international lawyer. So he studied history and law at Stanford, Yale, and Harvard Law School. And he also worked as a lecturer at Stanford, McGill, and Berkeley. So I have to mention for this session that Dr. Landauer published in 2019 in the London Review of International Law a fascinating paper on the prominent international legal historian Alexandrovich, known largely for his advocating of the East imprint on international law. And our second speaker is Parvati Menon. She is an adjunct lecturer in international law. I will start again. So Parvati Menon is an adjunct lecturer in international criminal law at the University of Helsinki. She studied at Harvard Law School and at LSE, worked at Max Planck Institute in Luxembourg, the University of the Gambia, and also at the National Law School of India University in Bangalore. Now she's writing a PhD entitled Protective Empire of Law, a History of International Laws, Humanitarian Authoritarian Alliance. So I'm very pleased to welcome them in this seminar. So today, Dr. Prabhakar Singh, Prab, will be exploring the transformation of the laws of nation through the history of the Indian princely states, and Dr. Karl Landauer and Parvati Menon will provide with the commentary. So I'm really thankful for Prabhakar, Karl Landauer, and also Parvati Menon's acceptation to be part of this seminar. I'm much honored, and yeah, I'm really looking forward to this presentation. So Prab, you can start if you want. Yeah, thank you.
Thank you, Sophie, for the kind invitation to speak at your seminar. I think during the lockdown, this is one of the things I was looking forward to. So in some sense, it got me going, and I look forward to this. And I'm very thankful to Karl and to Parvati to have agreed to comment upon my work. I stand to learn a lot from them, given that they are both historians of international law, and I'm trying to become one. My topic of today's presentation is Indian princely states and the transformation of the law of nations in the 19th century. So it has three components, as you can see. Indian princely states, that's the first component. The second component is the transformation in the 19th century and of that of the law of nations. I will start with the facts and some description about what are princely states, and then get into why it is important today to study the life of princely states and how they've impacted international law in certain ways. This has also become a popular area these days, as I see a set of new researchers, both historians and lawyers, studying princely states. Because princely states were roughly, as VP Menon in his classic book of 1956 said, 700. So actually, if you look at the accounts, the number ranges from 450 to 700, depending upon how you define princely states. So In other words, it's actually a large group of um, states. Therefore, one can expect to find a number of things depending upon which set of states you're actually looking at. In his classic 1956 book, V.P. Menon, who was actually secretary to the Home Minister under Nehru government, who was tasked with the consolidation of princely states and sort of kind of convincing them to join the Union of India. Menon says the states range from autonomous to those controlled by the government of India, the British government, to owners of a few acres of land. So it was really large. And they had different origins. So that is very important in terms of legitimacy. The numbers are close to, let's say, 500, but they really came from their different origins. So for us lawyers or legal historians, what is important is to actually understand the legitimacy or the act or a grant or the legal document that actually gave them recognition and of what kind. So, so for instance, if we'll take the number of states to be, let's say, 500, only 118 of them were called salute states. Now the British, which was a paramount power, and throughout, from 16th, 17th to 18th century onwards, it was a long process of the British government trying to actually subjugate princely states, and depending upon their own imperial requirements or the size of the states or the kind of resistance they felt from the state, which were also in collaboration with competing European powers. So some states were collaborating with the French or the Portuguese to fight the British imperialism. So depending upon what kind of states they faced, they created or created a hierarchy of states. Or in other words, British colonialism was able to introduce a hierarchy of states among the princely states. And one of the ways in which they ordered the state was granting them gun salutes, right? That's very standard way. So they, based on how important these states were, they would be granted different gun salutes. For instance, in India, the highest gun salute was 21. So states such as Hyderabad, Baroda were given 21 salutes, right? That's the highest in India. And it would go down as 21, 19, 17, 15, 13, 11, 9, right? So that was one category of states in a decreasing order of gun salutes to non-salute states, actually. So that is an interesting example of how the British were actually, kind of grading states. It was grading states based on how, what was their size, what was their population, what was their, GDP, etc., etc. So they had a mechanism to actually size them all. You can compare, for instance, India's highest gun salute state, let's say Baroda with 21, with Thailand, which was 31 gun salute. So you can see that Thailand was much higher, and therefore a much more important state, although a princely state. So, not as a matter of culture, but as a matter of law, if you look at the participation of independent states in the League of Nations, right? First World War, around First World War, League of Nations, you can see that some of these states, princely states, were much bigger. Thailand, for instance, or Iran, for instance, these were much bigger. As I said, Thailand had 31 gun salutes, whereas India's biggest state had just 21. So again, you see the British imperialism trying to create a grading of states. We'll come to why this is important, but these are some of the facts we need to know for the uninitiated, because even for many Indians, princely states can be a very exotic topic, so to speak. So it was in 1927 when the Maharaja of Patiala was a Sikh ruler. So the other thing in India is, for instance, that the states or rulers were of various religious communities. So we had Muslim rulers, Mughals were Muslim. We had Sikh rulers. Maharaja of Patiala was a Sikh. We had Hindu rulers. The Rajputs were Hindus. Then we had, so basically, so Muslims, Hindus, Sikh, even a Jewish ruler for a short while around Cochin. That's a different story, not covered here. But actually, rulers of all nationalities and sorry, of all religions, and that has to do with the history actually. So it was in 1927 when the Maharaja of Patiala, speaking in London, clarified, and he spoke about the origin of different states. And this is what he said, and I quote, he said, "I want first of all to deal with the rather common mistake, which I believe is held in many quarters, that the princely states owe their existence to the British power. Out of the 450 states, big and small, which are enumerated in the official list published by the government of India, the vast majority were in existence before the British flag was ever seen on the shores of India." So what the Sikh Maharaja of Patiala is saying, that yes, there are some states that became states because of the grants or redistribution of older states by the British, but a vast majority of big and small states were present before the British set foot. So India, in that sense, was a conglomeration of small and big princely states since time immemorial. This is what the Raja is trying to say, and you will see why this becomes important later. Not just the Raja himself, but a pamphlet titled The Native States of India, published in 1863, actually says that there are two kinds of states now after British intervention. You can either call them subsidiary or protective states, right? So that's another distinction between subsidiary and protective states. And when the British recognized a particular state as a subsidiary state, the British would sign a different kind of an agreement as compared to a state that would be recognized as protective, which means that along with the grading of states, the British were also producing a graded kind of colonial documents or colonial instruments, right? Some would be called arrangements, others would be called treaties, and yet others would be known by the Persian name sanad, right? So they were, which is the word for grant. So in order to create a grading of states, the British are also creating a grading of documents, right? And that actually determined the legitimacy in an increasing or decreasing order of a state, and therefore its sovereignty, right? So, but the 1863 pamphlet actually speaks about some of these states, however small, being, and I quote, ancient subdivisions of India. So even the British document or British observers or independent lawyers and diplomats sympathetic to a particular state were able to recognize that India during the 19th century presented a chessboard of states where there was a grading, and they had different origins. Some were very recent, like 50 years, 10 years. In fact, some of the states were created after the first mutiny, that is the 1857 mutiny. But some of them were so-called ancient subdivisions of India. So you see this wonderful variety of states, and colonialism then had the task of grading them, right? So the most important law, or at least let's say approach, in grading of state was in the middle of the 19th century under Lord Dalhousie, and it's called the Dalhousie Law. Lord Dalhousie Law. What did he do? It did two things. Lord Dalhousie Law had two components. The first was that the native chiefs or the kings that died without heirs, natural. So if the king had no child, then that territory would lapse to the British government, British Indian government. The doctrine of lapse, as it is called. So this is a common law doctrine of imperial value, and this doctrine, application of this doctrine by Lord Dalhousie, allowed the British government to acquire a lot of princely states or paramountcy over princely states by this doctrine of lapse, where if a king does not have a child, childless, then the British sort of take over the administration. And even within that administration, of course, it depends whether it turns into a protected state or a subsidiary state. So again, none of that is uniform. This we have just that the states are not uniform and they are numerous. The way in which each state is dealt with is also different, and that makes it very fascinating. There's no uniform or universal law actually there. It's actually diplomacy mixed with a kind of sort of use of common law. And second aspect of Dalhousie's law was the banning of British subjects from accepting titles from the Mughal, right? So now, from 1600 onwards, when the British first landed on shores of India, they actually got an executive decree from Jahangir, the Mughal, the great Mughal, right? So that's how it started. But by the time we reach the 19th century, the British, government is actually banning the acceptance of title by native subjects from the Mughal, for the simple reason that if the Mughal actually want to create more alliances, they could grant titles and create new kings, and that could actually then help them fight against the British. So there are two aspects of this Lord Dalhousie law, which means that in the middle of 19th century, suddenly the Mughals, who were the biggest rulers in the country, lost their ability to create to create subdivisions to offer grants, which was actually a direct attack on their imperial, or let's say sovereign powers. And in law, right, in law and diplomacy, only the British could actually create new states. So you suddenly see that that's a big event, which means that many states ceased to be de jure states and they became de facto landlords, right? So because now if the British seize their title, or they stop states from they stop the Mughals from actually giving them titles, so a lot of these states actually just became de facto states, not de jure states, princely states, in a sense big landlords. So you see that the intervention by the British, particularly by Lord Dalhousie, is creating some kind of a churning among the princely states, where new states are born, old ones are decaying, they're being broken up. So all kinds of things are happening, right? We are still with the facts, we get into the legal part, but given the variety that we have, this is very important. So given that VP Menon speaks about 700 states and the Raja of Patiala speaks about some 550 states, more important than the actual number of states, what is important to know is how they were actually organized. So we can actually organize all these 500 states into federacies, actually confederacies, and we are actually able to sort of see 3 or 4 confederacies working. The first is, of course, the Mughals, the most powerful center in Delhi. And so there are other Muslim states that were away from Delhi, but were part of the Mughal confederacy. Then we have the Rajputs around current Rajasthan, actually, Rajput confederacies. Then we have 6 states on the western side, so in Punjab, Indian Punjab and Pakistan Punjab now, called Sis Satluj states. So they span between Satluj, which is a river now, in Pakistan, to New Delhi, right? So these were confederacies, sometimes built around religion, right? So we have these large confederacies: Mughals, the Rajputs, and the Sikh confederacies. And at the end of 18th century, what happens is a new confederacy actually rises to power, that is the Marathas. And they were really powerful. And then they became so powerful that they subordinated all the existing confederacies, extending their rule from New Delhi in the north to all the way to Tanjore in current Tamil Nadu. So large confederacies of 6 ruling family. And there was a time when actually they were giving protection to the Mughals, the original legal emperor. So that also actually created this situation where the Marathas actually became the de facto rulers of the country. So even when the Mughals were de jure rulers, Marathas, by extending their protection to the Mughals in Delhi, became the de facto rulers of the country, which means that now that the British are actually intervening in the affairs of the state, they are now faced with the Marathas. Very interestingly, the Marathas are seeking support of the French, and their commander was actually a person sort of, trying to modernize their army, and in the first Anglo-Maratha war, it's actually the Marathas that win, defeating the British. So there was actually a time when Indians would have thought that British rule will end at the hands of Marathas. But by the time of the third Anglo-Maratha war, which is 1818, the Marathas lose. And that's when you can see that there's a lot of redistribution and sort of redoing of states by the British, because the most important power has now fallen and the British couldn't be stopped, actually. It is important to note that the Marathas were seeking the help of both the French and the Portuguese, because one of the very important cases that India had with Portugal, the right of passage case, is a case about the Marathas having given away certain villages to the Portuguese to put down revolts, right? Which in the right of passage case, the Portuguese argued to be a grant of sovereignty, which was contested by the Indian state, saying, you know, contracting out is not the same as giving sovereignty. But so my point is that these documents are not, these documents are were actually also read and evaluated by the International Court of Justice. And in fact, and Carl will agree with me here, is that one of the impacts of Professor Alexandrovich was that before the matter went to the ICJ, he had done a lot of works on native documents and treaties and sanans, and one could argue that his reading, Professor Alexandrovich's reading of these instruments, you know, these imperial instruments, fertilized the views of some of the developing country ICJ judges when they looked at, when they read those documents in favor of India and against Portugal. So as I said, there was a time when the Mughal had declined and Marathas were offering them protection. So Mughals are de jure rulers and head of the all the confederacies in India, and Marathas are de facto because they are the ones, you know, actually maintaining that order. Maharaja of Patiala actually makes a very important observation in relation to how, with the rise of the Marathas, the scheme of sovereignty in India changes among princely states. And there's a long quotation that I would like to read for our listeners. So the Maharaja, before the Royal Institute of International Affairs, says, "The Marathas, at the climax of their power exercised, it is true, an overlordship of somewhat oppressive type over those kingdoms which did not submit, but had to be compelled by force of arms to acknowledge their supremacy. But these kingdoms were not destroyed, and there was never any question either of destroying them or of replacing the ancient dynasties. The anxiety with which some of the ancient Rajput kingdoms, which suffered severely from Maratha sway, sought alliance with and protection from the British, did not arise from any fear of being annexed or abolished, but simply because they hoped to exchange a heavy tribute for a light one. Indeed, it was probably this realization of the comparative merits of a British over a Maratha empire which finally turned the scales in favor of the British. For if the Indian states at the beginning of the 19th century had not come to the conclusion that British supremacy was preferable to Maratha supremacy, the verdict of history might perhaps have been different." This is the Maharaja of Patiala speaking about how it was Rajput confederacies and a number of Rajput princely kingdoms that chose to join the British simply because in the market of princely states, they saw they could exist with British with less taxes, you know, because when the Maratha rose to power, they started a scheme of taxation called chauth, which in Hindi, which in English would translate into 1/4. So they were actually collecting this chauth, or 1/4 of the you know, from farmers and kings. So this tribute or tax, if you want to use that term, was very high. So it is because of that system that a lot of this, you know, princely states joined the British hoping to get more protection. So what you see here is that it's not a plain nationalist reading that we are actually given these days, where we, you know, sort of try to do this Hindu versus Muslim, or, you know, Sikh versus Muslim kind of a debate about princely states. That's not true. It's actually the Marathas were Hindus who actually had the most oppressive kind of regime, where the princely states were not happy with them and they sided with the British, and that's how their decline actually started. So 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 that is, but that is essentially the start of the 19th century, when all of this reordering happens, because the Marathas lose by 1818. That's the Third Anglo-Maratha War, and then by the time the British completely control the paramountcy of the over the princely states, and then it simply becomes a question of formalizing it, right? So that's an interesting part, when the British start to formalize. As I said, the types of princely states was numerous. Therefore, the British sort of dealt with them in different ways. So if you look at the European and, if you look at the interaction of European and Indian actors, you see very interesting things. For instance, the British had treaties with roughly, let's say, treaties or sanats or arrangements with roughly 450 princely states. The Portuguese had contracts or sanats with the Marathas. The Maratha Portuguese sanats were, as I said, subject of the right of passage case. The French had an alliance with the king of Mysore, who was Muslim, Tipu Sultan, who lost in 1790 at the end of the 18th century. So in some ways, you can also read, which is not the main focus of my paper, but you can actually read this skirmishes and this competition among princely states as a proxy for European European wars. Clearly, the French and the British and the Portuguese are actually fighting, and you have to understand how it is working among the states, because these states wanted to claim that they have sovereignty, or they are feasible states based on how good they are with their administration and whether they have army. So naturally, they are either going to the French or the British or to the Portuguese for modernizing their army, right? So in many cases, their commanders would be essentially Europeans, right? So, and their job would be sort of creating a modern force, army, etc., etc. So that is the sort of ontology of states, so to speak. And it is because of that you see that these three important powers, the French, the British, and the Portuguese, are actually using states as a proxies for their own wars. Coming to specific examples, I know Parvati is also working on Edmund Burke. Burke is a very important figure in India for a number of reasons that Parvati is writing about. Here, what is important for us is that Edmund Burke was advisor to a number of southern states. For instance, Burke was London advisor or agent, so to speak, of the Raja of Tanjore. He was, and because he had this sort of, you can say, sympathy for the native rulers, you can see that his arguments go against the misrule of British East India Company that is manifested in the trial of Warren Hastings. That's the biggest event. But if you look at other sort of smaller events, for instance, in his letters, so I found his letters and published in different sources. And at one of the places, Burke says, the very cornerstone of all reformation in India rests in preventing our people, that is Europeans or British in particular, from jobbing with the princes. This kind of dealing with the Nawab of our court, Burke said, has almost already irretrievably ruined a great part of India. So you can see that he's actually in favor of native sovereignty, as the agent of one of the kings from southern India, from Tanjore. But again, as you can see, that even within that, religion plays a part, because some of these southern Indian states, if they were Hindu, they were either in a Hindu confederacy or independent state, in war with some of the Muslim states. And so some of the arguments actually depends upon which state you're rooting for, actually. But what is important is that, and that's the main sort of, besides the description of the princely states, that's our main concern as lawyers. How in these battles, legal battles and sort of defense of these princely sovereignties, the Indian princes hire British or European experts, and how they begin to sort of use the existing body of international law to make a case for them. That is sort of the main emphasis of my presentation. As I said before, the mutiny of 1857 led to a rebooting of relationship between India, princely states, and international law. For instance, 1857, after 1857, the British, which had already stopped or made illegal the grant of title grant of title by the Mughal, were now in the business of granting titles. So it's like a creation of a license rule, right? So having suspended the power of the Mughals to give titles, they are the ones, the British only, after Dalhousie, the British alone can actually create new sovereigns by giving new grants or new titles. So I have cited some examples in my paper which tell you the many ways in which they were able to do this. For instance, Raja of Mulim accepted the jurisdiction and sovereignty of Her Majesty the Queen of England, extending over the said land and over all persons thereon and to all offenses committed therewith. So you can see that by securing the protection of the British, the local kings are offering them jurisdiction, both criminal and other jurisdiction, to the British, which means that you're creating a situation where you will invariably end up choosing British law as the applicable law, right? And this is the kind of story that is now being told by those who are using jurisdiction instead of, so who are using the extension of jurisdiction by empire as a way to study imperialism and colonialism. There are many examples. I mean, one of the funniest example I came across was when the British government bought the jurisdiction and, of certain tribal chiefs by setting in agreement, written agreement. So sometimes they would mention, for instance, 80 bottles of rum and 2 kilos of opium as exchange gifts, annual gifts for securing their protection. So you can see that they're using a whole range of devices to actually secure, to extend their protection, right? And to extend their paramountcy. So then we reach the year 1891, where by an executive order, the British government actually clarifies and perhaps casts in stone the position of princely states. And I am basically quoting Westlake from 1910. Westlake, a prominent international lawyer, and this is what he has to say in 1910. And this he says while reviewing the second edition of this book by Lee Warner, who was a famous author, a British diplomat, bureaucrat, and author of a book on princely states. So this is what Westlake says in Law Quarterly Review in 1910, and I quote Westlake: "The British Indian government has spoken on the subject with no uncertain sound. In its official gazette of 1891, there appeared a notification that the principles of international law have no bearing upon the relations between the government of India as representing the Queen Empress on the one hand and the native states under the suzerainty of Her Majesty on the other. The paramount supremacy of the former presupposes and implies the subordination of the latter. The only criticism to be made on that notification is that it would have been more accurate to speak in it of international law simply than of the principle of international law." So Westlake is actually mildly criticizing a notification by the British where instead of saying that international law is of no use while in describing the relationship between princely states and the British Queen, they speak of principles of international law. So what Westlake is saying, that is actually makes it less clear. If they should say the notification should have just used the word international law. So you can see that Westlake is also in favor of the subordination of sovereignty going forward. So this brings us, so this is basically the short history of princely states, and how they were moving from independence to confederacies to complete subordination by the British. Why am I doing this? Well, in the last 20 years, we have seen this so-called turn to the history of international law. And as I read the turn to the history of international law, I see two trends now. The first is, of course, led by people like Marty Koskenemi, Karl Landauer himself, which I call the turn to biographies, because as we know, Karl has actually written about a lot of non-Western lawyers, and in that way has educated us about how international law is functioning beyond the West. Unlike Koskinen, whose so-called turn to history is a biography of only Western intellectuals. Do I have 3-4 more minutes, or should I? Okay. So that is sort of Koskinen versus what is happening now. So in the works of Benton and Ford, it is less about biographies or individual works of scholars in the 19th century and the early 20th century, but more about the mechanisms that the British Empire was using to take international law from the West to the East. So the universalization of international law for Benton and Ford is through jurisdictions, by extending jurisdictions, of which I gave examples just now. So then we see this turn to biography versus turn to jurisdictions. And then there are sort of, and I'm actually very inspired by the works of Benton and Ford, which I sort of use extensively in my paper. And there's sort of, so essentially we now see two streams of the history of international law, biographies and jurisdiction. And I think I'm on the side of jurisdiction, simply because I think that is something that sort of gives, as someone located in the global South, I think that picture is clearer to me than the neo-fascist on biographies only. I would so basically in this I mean, what am I saying? So I have 4 observations before I conclude. My first observation is that the native petitions and court litigations against the British paramountcy are central to the transformation of the law of nations into international law during the 19th century. Second, common law and international law ensuing from the common law fattened on riches from the Indian colony at a time the princely states struggled to understand and affirm their legal position against the imperial law. Their political instability and the alleged normative scarcity brought good business for the advocates in the heart of empire. Aiding the empire, the British courts before and after 1857 did not just bend international law in favor of the EIC, East India Company, it also passed on the cost of creating such a law to the colony. So this is very important, which means that we reach the final argument, because in international law, when we speak of civilization, we speak of law giving. A country is called civilized if it has laws, right? And in that logic, we see the law flowing from the West to the East. But the story is much more ontological and much more nuanced. And therefore, my final argument is that to the extent law represents civilization, the discursive formation of common law resulting from the transformation of the law of nations in the Indian colony rejects the idea of the periphery as only the receiver of the law. The Indian colony supplied common law to England instead. This finding at the very least appends the civilizational thesis of the 19th century international law. So that is my sort of thesis, which I've tried to prove by sort of studying the princely states and then turning to the turn to jurisdiction in international law. Thank you.
Yeah, thanks so much, Prab, for your presentation. It's really fascinating. So we will hear the first comments from Karl and then directly to Parvati. So thanks so much, Karl and Parvati, for accepting to comment on Prab's paper. I'm very looking forward to your comments, and then Prab will have time to answer the 2 comments, and then the floor will be open to the questions. So thanks so much for providing the commentary, and Prab for giving us this very insightful presentation. Thanks so much. Yeah, so Karl, you can start.
I have to unmute there. So first of all, I'm going to be focusing more on Prab's paper than his presentation, although I welcome the introduction, the broad introduction to the princely states that he's provided, especially the power structure among them, and of course, the British attempt to create an administrative taxonomy. And so those things I would welcome in the paper itself. But I'm going to focus a little bit more on on the written paper, which is a wonderful treatment of the Indian princely states, and it's an analysis of what he's just said as the move from the law of nations into international law within the context of India. In his narrative, Prabhakar delves into the litigation. So the paper itself really focuses on litigation, the litigation history of the Indian princely states, attempting to protect their sovereign prerogatives, primarily in litigation, especially as brought before the Privy Council in London. And he talks a lot about the costs of just going to London itself, as he mentioned today, being this additional hurdle for Indian princely states, having to either hire, send counsel to London or hire London counsel, etc. With his significant focus on litigation, Prabhakar is able to set out the arguments that the princely states marshaled, as well as the slow march, as he suggested, losing ground, the slow march of their losing ground in the shifting dynamic of the British imperial legal framework in India. The princely states, of course, represent a special case in British rule in India, because they were not included within British India itself. That is, they were not, as he will tell us, territories directly governed under the presidency towns of Calcutta, Bombay, and Madras. So the princely states became part of the intricate dance in British imperial rule, as Prabhakar and other scholars have underscored. As he has suggested, we also see in Lauren Benton's writing the newly published articles of Zach Leonard and Priyasha Saxena, and an article by Sarath Pillai. Repeated references are made to muddled and confusion, and fit into what Saxena identified as a site of the, quote, fuzzy frontiers of national, imperial, and international law, end quote. And Saxena states outright, the princely states were considered to be sui generis, both by British and state officials. You can still hear me, right? I will return later to the uniqueness of the princely states in the British imperial world, but for the moment I am persuaded by Prabhakar's pointing to the princely states as evidence in the narrative attempts to litigate their sovereign prerogatives as sitting at the core of the development of international law in India. Most of his story focuses not only on their litigation record, but also on the attempt, as he suggested today, to eliminate the princely states, slowly but surely, as in Dalhousie's law, as he suggested, creating avenues for eliminating princely states, primarily by the use of the common law framework of lapse, whereby princes dying without heirs natural would lapse to the British government in India. But interesting, Prab mentions in his paper the creation, and he did today, the creation of new states after 1850. I'd like to understand a little bit more about why, although he suggested today some of the reasons why, in order to get more control. I was wondering whether did it evidence, to borrow from Hobsbawm and Ranger's book, a colonial invention of tradition in which there is a colonial need to create a traditional society or culture where the building up of polity aids the imperial efforts? That's a question. Or are they the result of various backroom intrigues that's closer to what he suggested today, the stuff of Benton and Ford's rage for order? But Prabhakar's key story is the extension of British jurisdictional imperialism, symbolized by the move from the law of nations to international law, by which he means the move from the natural law of nations to a 19th century positivism that identifies monadic units of states as the only subjects and significantly based on a Eurocentric standard of civilization. As he tells us in his paper, this moves Oppenheim in his international law to identify Siam and Persia as anomalies. In essence, Prabhakar is channeling the international legal historian he's mentioned today, C.H. Alexandrovich, in his distaste for the term international law and his insistence on using the law of nations, because obviously international law was identified by him with the 19th century positivist exclusion of most of the world. In Alexandrovich's words, quote, "The time has come to return to some of the vital foundations of the law of nations, a term which is more meaningful than Bentham's international law, which," and this is the interesting part, "continues to bear the seeds of its own crisis," end quote. Not that Tony Angie would agree that the earlier law of nations was not already structured around colonial power. Prabhakar identifies the special case that the princely states pose for British colonial rule in the Indian subcontinent. The princely states did pose a special issue, not only within British colonial rule, but also with the creation of independent India, as he suggested. So there were questions regarding exactly how they would fit into the Indian constitution. If the new book by Madhav Khosla, India's Founding Moment, focuses in his discussion of separations, he focuses primarily on religion and caste, and has maybe a page on the states. Alexandrovich, for example, devoted a chapter in his book on the Indian Constitution to Indian federalism, in which he focuses his narrative largely on the princely states, starting with the impact of the Government of India Act of 1935, the Constitution itself, and early amendments to the Constitution. Also, he has an article arguing against attempts to say, hey, this Indian Constitution is really not federalism, but quasi-federalism. For Alexandrovich, it's true federalism. So Prabhakar is correct about the lasting character of the question in the princely states. And clearly the stakes were high, both in the period of his focus as well as later, as he discussed today. Nevertheless, to pull the lens back, to look more broadly at the British imperial framework, the question might be how the controversies around the princely states fit into the greater landscape. In 1962, the Nigerian international lawyer Taslim Olawale Elias, he's an international lawyer as well as being Nigeria's federal attorney general and minister for justice, published a book entitled British Colonial Law, a comparative study in the interaction of English and local laws in English dependencies. In it, Elias focuses, stretching geographically across the entire British Empire, despite the fact that most of the subject countries were already independent. So his own Nigeria 2 years before, India for 15 years, he still is talking about the dependent landscape. Elias sees, with some degrees of variation, some variation in degrees, a common picture of English law being applied to certain substantive areas, but with customary law judged by customary courts covering certain other areas, for example, marriage. The judicial jurisdiction analysis is, of course, not the same as the powers that Prabhakar is describing, and are brought to the brought in the privy court cases. They're essentially jurisdiction in another register or another level, especially since British colonial innovations, and this is a question I have, were sometimes exported or adapted elsewhere in the British colonial world, such as adaptations of the India Penal Code. It might be interesting to look beyond the sui generis view of the Indian princely states to see them in comparative context, or at least to the extent to which the cases discussed by Prabhakar made broader impact. Was there reception elsewhere? Were they discussed? And then, with the positivism that is at the core of his story, I'd like to point out the fact that 19th century international law publicists did an immense amount of slicing and dicing with regard to sovereignty. If we're told that W.E. Hall outright denied international personhood to the Indian princely states, his chapter on the subjects of international law is significantly entitled Persons in International Law, and this is the interesting part, communities possessing an analogous character. And he writes that states commonly understood to be subject to law in a partial manner are classed under the several heads of states joined to others by a personal, real, federal, or confederate union, and states placed under the protection or suzerainty of others. George Grafton and Wilson and George Fox Tucker devote a full chapter of their textbook to legal persons having qualified status, which is divided into sections dealing with states that are members of confederations and other unions, neutralized states, protectorates, suzerainities, corporations, individuals, insurgents, belligerents, and communities not fully civilized. And Wheaton also has to address the subject of semi-sovereign states, as he put it. A good deal of the literature on India and the princely states focuses on Henry Sumner, Maine, as Prabhakar will know, and his definition of divisible sovereignty. But most 19th century international lawyers had to address varieties of polities in some way or another, even if part of it is an attempt to address unequal treaties, the ability to make a treaty that somehow is enforceable without really giving sovereign rights to the treaty party. I've long thought that the state-centric approach to international law had been permeable. It's always been permeable, and its history may be shorter than often suggested. So that's one of the challenges I would bring up to Prabhakar, and those are my comments.
Oh, thanks so much, Carl, for your comments. Yeah, thanks so much. So, yeah, Parvati, if you want, you can just start.
Okay. It's a tough act to follow after Carl Landauer has spoken, but I'll try my best. Thank you so much for inviting me, and Prabhakar, thanks for having me read this paper. It was a really interesting piece of work, which, I mean, I can tell you how I read it, and you can correct me if I'm wrong, if I've assumed things without it being true. So I saw your paper as kind of the rise and fall of native sovereignty. It's how at least I envisioned it when I was reading it. It's like, okay, this is the period in which the native sovereignty is being exercised, and this is the period in which it's being taken away in some form. And India is a really difficult choice. I mean, as you described it, it's a chessboard, and it's probably why I stay away from writing about India, because it's so complex and it comprises of so many different governance models that it's so difficult to create anything. I mean, not that the British Empire ever really had a method to their madness, but even if you want to say something to create a kind of pattern, India is difficult. And how I saw your work within the GH&IL approach is that what I found most commendable in your work is that you strike this really delicate balance in the way that James Guthy describes it between a contributionist and a critical stance. So I find that balance really hard to strike, and I think in my own work I struggle with giving agency and at the same time not really discrediting, I mean, kind of crediting the subjects at the same time also not downplaying the exploitation. So I think that's a very difficult balance to strike, and you've done a great job. And I applaud the sources. I mean, I was reading, I was looking at some of the names that are there. I think there are so many names that Western scholars probably in international law don't care about, or don't read, or don't have never ever come across. And I think it was eye-opening for me to come across those sources. So really great. There are a few themes that I want to touch upon, and I mean, they might not really be provocations, but maybe I'm just playing devil's advocate a little bit to ask you what you think. And some of those points Carl has already touched upon. So the first one is the concept of subjecthood, and I'm really interested in it, and I'm also curious how you use it, or how you really define these subjects that you speak of. Now, so personally, I think that restricting subjecthood was an important feature in the semi-civilized, semi-sovereign territories, sometimes also called protectorates. I mean, there were so many iterations of these semi-sovereign territories. So the point is that the British were themselves so perturbed by these new kind of creations of the 19th century that they created a separate category for the subjects from these protectorates, especially in the African protectorates. And a certain case from Bechuanaland protectorate created a separate category of protected subjects who were different from British subjects. So, and in terms of the rights and obligations that these protected subjects had, it was different. It was a matter of status, which differentiated the superior status of British subjects from the mere protected status of the native subjects. And this was a way of exercising control over them without giving them the superiority of being British, and at the same time kind of expecting obedience to the crown from these protected subjects. So I'm curious what kind of subjecthood princely state natives possessed. Because you speak of migration of British subjects a lot, you use the phrase British subjects a lot, and I don't, I want to know more whether you use them as it being a superior status or as it being an inferior status. So it would be great if you could say something about that. And this migration aspect that you spoke about was fascinating for me, because if you think of British subjects, and again, I'm assuming here, but I don't know if you mean the British subjects as being actual English men, or if you mean them as being Indian natives who were granted some kind of status. It's curious for me, this kind of level of civilization being higher in these princely states that allowed for or perhaps attracted this migration. So I'm curious about that. And that's also, in some sense, the question of this Kannada Menon, which I was curious about that, because if such a person who was a low-ranking official of the East India Company was granted a status, it could no way have been equal to the status of a British subject living in the United Kingdom. So I think that's one aspect of it that I'm curious what you think. The second one is, of course, the large chunk of it. It's the sovereignty topic, which perhaps is so huge that if this is something that if these questions make any sense or they're outside your purview, I would totally understand. So my question is, when you think of princely state sovereignty, I'm curious what that even means, because I'm curious if you gauge the articulations of sovereignty by reference to European conception of sovereignty, as you discuss in relation to Vattel, because that to me is interesting in and of itself, but also perhaps challenges in some way the extent of the contributions made by the princely states. And let's say that even if I am convinced that princely sovereignty was not a British creation at all, the question then turns to, what did the British really make of this sovereignty? Did they think of it as something that helped them, or did they think of it as an obstacle to their exercise of control of India? And because even the aspect of lack of internal interference as an expression of native sovereignty can be an expression of British disinterestedness in spending the kind of money that is required in internal administration. And because I study a lot about the African protectorates, one of the things that I see is they only wanted to have access or control over foreign relations because they wanted to prevent them from trading with the French or perhaps the Germans. And so in that sense, when you mentioned in your presentation that it was somewhat of a European war, I totally am on board with that. And that brings me to the paragraph you cite and that you also quoted here by the Maharaja of Patiala. And to me, it seemed like a glowing review of the British Empire in the way that I saw it. I don't know if you saw it differently. And it's so typical of the British, they come in to save the day from the despotic rulers who, these poor local chiefs are suffering at the hands of. And here it's the Marathas, and it's been so many other rulers in so many other parts. And the interesting thing is it almost read like mendacious British propaganda to me, like when I read that paragraph. So I looked at, where it was published, and it was the, as you mentioned, the Journal of the Royal Affairs, which is actually a journal that was founded by Lionel Curtis, who was one of the biggest apologists of British Empire and who was so against any kind of real recognition of a federation of even the Commonwealth of States. So I'm wondering if that's worthy of some scrutiny, like this production of academic knowledge, like where it happens and who is controlling it, right? So that also tells perhaps more into the story you're telling. And the last point, if I have a few more minutes, Sophie, yeah. The last point is the difference between common law, law of nations, and prerogative law. To me, they all function a little bit differently. So I wonder what you think about that, because especially in the case of India, one of the main reasons for, I mean, of course, this was something that transformed quite a bit. So it's hard to really explain any kind of real pattern or real trend. But it's fair to say that the common law prohibited many of the things that the law of nations did not. And one of them was monopolies, for example. Another one was slavery. And these were all things that the common law, if you were on British territory, you could not do it. But you could do it if you were in some extended territory, which was not tantamount to British territory. So therefore, you could grant the EIC a royal charter and have them have full monopoly over a territory like India without any violation. So there was a reason why the law of nations was a favorable way to really allow the governance outside. And similarly, the prerogative power was a sense of, you know, allowing the orders in council, or almost like an absolutism of the crown in determining what laws could apply in the territories and not. And against this background, I would like to hear more about this fall of native sovereignty that you described through the kingly litigations. I mean, does it play into this narrative that I just described, or is this narrative completely outside the context of how these new kind of principles, etc., from these princely states contributed to the language of the law in British or perhaps international law? And yeah, and I'll end there. Thank you.
Yeah, thanks so much, Parvati, for your wonderful comments also. Thank you so much. So Prab, yeah. You have to unmute yourself.
Yeah.
Better.
Thank you, Carl. Thank you, Carl and Parvati, for the comments. I appreciate all the comments you've made, and I've noted the questions you've raised. What is reassuring is that in commenting, we seem to be at least talking about the same issue in the same language. At least this topic isn't really so off the mark. So I'm happy about that. Yes, in my presentation, I focused mostly on the history because it's something that needs to be reminded of, and therefore I was not able to actually spend much time on litigation that Carl spoke about. So in that sense, after describing the taxonomy, as Carl says, administrative taxonomy of the British vis-a-vis the princely states, the main focus is on those litigations and how law is emerging, common law is emerging, what kind of common law is emerging in those litigations. So these litigations are very important because you have to imagine the states, going all the way up to England to sort of fight their cases, and there are a number of issues that they face: the issue of financing, and all kinds of political hurdles that I've counted for in my paper. So by using that, my main intention is to show that if civilization is seen as law giving, which is the classic 19th century assumption about international law, the story is more nuanced. It is not a one-way reception of law from outside. The actual practice of lawmaking is more contributory if you go more ontological. So, which means that even if the decision is against the princely states, it has been done at their cost. They funded the litigation, they did all of that, and maybe the decision is against them. So they have more agency in lawmaking, therefore in the making of civilization. Therefore they are not this receivers of civilization, but they are actually contributing in the making of, so to speak, civilization as law. In relation to the rebooting of sovereignty and creation of new sovereigns, or petty states as they are called, or tribal chiefs, after 1857 mutiny, Carl reminded me of the works of Hobsbawm, who speaks of the colonial invention of traditions. I think it's a combination of of Hobsbawm's colonial invention of tradition, vis-a-vis the need to create proxy states, right? So that the more you create, the more they will add to to your vote, for instance. So that was a way of I think it was actually small steps, a small step in the grand scheme of administrative taxonomy, because colonialism essentially meant encountering them and then placing them within an order. So that was part of that exercise. In relation to Parvati's question of subjecthood, yes, I found very interesting. So that's another side. So the first side of civilization is that India was not receiving, and if you look at princely states, they were actually making it. It was a collaboration actually. And the second aspect of the same story is the fact that while these territories were being annexed in the name of being lawless, right? You also have situations where princely subjects, so Indian natives Indian natives and sometimes British subjects, right, also moving to some of these princely states. So why would they move? And as I've quoted, why would they move from a good good place to the Wild West? So it was simply because some of these states were doing better at administration, as the works of Manu Bhagwan shows, that some of these states as Baroda and Cochin and Travancore were doing better than some of these English areas in terms of education and health. So, and finances, I mean, Hyderabad had immigration from British territory to Hyderabad because the Nizam or the governance was better, better finances. So a number of things, better health, better finances, a number of things. So the story of colonization, if it is broken down into these smaller units, cannot be read as the West, crossing the 7 seas and coming here to give law and administer. But the story is much more varied and nuanced, where you see these smaller stories of how, by movement in the opposite direction from Britain to princely states, you see that this exercise actually reverses the story of civilization, and that I think is an important story to tell. Yeah, these would be my broad responses, and these comments that have been made by Carl and Parvati will help me to sort of again revise my paper and sort of make it better and more nuanced. Thank you.
Okay, thanks so much, Prabhakar, for your answer. I already saw, now we will start the Q&A session. How did the legal framework with regards to sovereignty created at the time of British colonial expansion in India impact or inform post-colonial India's approach to princely states? And second question, were there any parallels and or dissimilarities between the British imperial legal framework to princely states in India and the former's approach to groups of states in Africa and vice versa?
Okay, thank you, Farhan, for your question. Second question first. Your question has been answered by Parvati because, as she said, she's focusing on African protectorate. So, your question, to the extent your question is were there any parallels or similarities between British imperial legal framework in India vis-a-vis what was happening in Africa? I'm not studying Africa, so perhaps I'm not best suited to answer that question. But Parvati did speak of African protectorates and how things were happening there. Coming to your first question, how did the legal framework with regard to sovereignty created at the time of British colonial expansion in India impact in post-colonial India's approach to princely states? Well, post-colonial India's approach to princely states was imperial, as simple as that. They already had the precedent of how the British were gradually taking sovereignty away from princely states. So between 1947, when India becomes politically free, and 50, when the constitution comes into existence, Patel, along with VP Menon, his secretary, they worked very hard to actually consolidate. And 99% of them actually agreed to join India in many ways, with the exception of Kashmir and Hyderabad, and also Junagadh. we know the Kashmir and Hyderabad story. Hyderabad, the government of India used force in Hyderabad to assimilate. Kashmir went to the UN. There were actually some other cases where some of the prime ministers of those princely states spoke of UN, to which Nehru and Patel didn't agree. So they went for complete consolidation. So it was actually, you can say, more colonial than the colonial government. And in relation to Northeast, as I said, they went for consolidation. So when it came to consolidation, they, of course, based on how important these states were, the negotiations happened. But it was from cajoling to conversation to diplomacy to brutal use of force. That was the whole range of devices that the government of India did use to actually consolidate. The second question from Aditi is, well, if you can write similar question.
Yeah, I will read it out. But just before, Parvati, would you also want to comment on the questions on priority states in India and the former's approach to group of states or states in Africa?
As I said, there was, in the British Empire, there were so many different iterations of control, from the Crown Colony to the protected states to royal charters. And I think there is a lot of similarity, at least after reading Prabhakar's paper. I found myself thinking that some of the language used by the chiefs is so reminiscent of letters that I've read written by native kings, asking for this protection to save them. So I think there are a lot of parallels, and that's why it was really such a joy to read it and think that, oh wow, there's so much more that I still have to read and understand about this empire. So I think, yes, there are parallels, and this is just one of the aspects, but there's probably more. Yeah.
Okay, great. Thanks, Parvati. So I will read the questions of Aditya Roy, who is a doctoral candidate in public international law in South Asian University in New Delhi. So the question is, is about the relationship between the crown and the princely states is of divisible sovereignty. So Prabhakar, can you draw a parallel between the relationship between Kashmir and India and princely states and crown? Another question would be, can the sovereignty be divisible, challenging the Austinian concept of indivisible sovereign in the states? Because if the sovereignty is divisible, then the entirety is no longer sovereign. So the so-called contrast between the approach of Maine and Austin, so though both being English common law scholars. And Aditya Roy is adding a question: which side do you support, Maine or Austin? Yeah, Prab.
Okay, answering Aditya's question, I mean, to be honest, I'm not very clear about the question, and I see that I did speak about these issues in the sense that it's difficult to actually cast things in stone, because in many ways sovereignty is read backwards. So if you make a claim of sovereignty, see, the logic is very simple, and when we try to determine whether a thing is a state or not, we have this positive law, which is the Article 1 of the Montevideo Convention. It says you have to have 4 things, right, to become a state. So and that is a 1933 law, right? Way before India became free. So between the First and the Second World War, and that has an imprint of the exercise of sovereignty of the Latin American states in the 19th century. So if that is the law, what is a state? The real debate is like a moot problem, right? That it's a moot problem. You have a definition of state, and every state actually tries to become. They try to prove that they are a state. And in that process, they use books, they use scholars, they use whole range of scholars from Anglo-Saxon world to wherever, they can get the resources from. So this is actually an exercise in argumentation, actually. So there are no precise answers to whether I'm Austinian or, more like Henry Sumner Maine, or whether Kashmir is an issue. As I said, Kashmir was a big issue because Kashmir was a 21 gun salute state. Had Kashmir been 17 gun salute state, it wouldn't have been a big issue. So Kashmir, along with Baroda and Hyderabad, were really, really powerful states, princely state, and they were higher state in the hierarchy of states. Therefore, their annexation, right, of course, use of power was much more scrutinized, right? So again, to the extent I understand the question, it's actually arguing backwards, right? You assume that a country, you're actually trying to defend the country. And if you look at the literature emerging from, let's say, Banaras Law School, which is a prominent law school, in the, from 1930 onwards, you see lots of work on princely estates, because you have to remember that these princely estates were huge employers. Where did Nehru come from? Nehru's father, Motilal Nehru, was an employee of a princely estate, right? So a lot of these intellectuals, lawyers in particular, were all divans or ministers in princely estates. They were better employers than the government of India, actually. Lots of people about, they have origins in princely estates, right? They were in the service of princely revenue department, or let's say law department. So what I'm trying to say is that so the way it worked was, you get trained in England, you come back, you find jobs with princely estates in the law department, right? So of course, when you do that, you're actually invoking that law already in that process. And many times, these were British, Britain-educated lawyers, either native or British, who were actually helping them find sovereignty, successfully or unsuccessfully. Eventually unsuccessfully, because after the independence, they all merged into the existing British India to create the India that we have now. And that, therefore, so many disputes about sovereignty of X or Y states, in Kashmir being one of the examples. So I can't say if I'm Austinian or supporter of Henry May.
So next questions from Swati Singh Palmer. She is assistant professor at Dharmashastra National Law University in Jabalpur. So how do you see the similarity between the narratives of subsidiary states and those who failed or weak states?
Well, again, failed and weak state is a post-colonial sort of, again, when imperialism again started. See, of course, there's a parallel, right? The way British Empire moved into smaller princely states to consolidate them and bring under their wings is similar logic that, after the Second World War and America becoming the imperial power, that's how they sort of used to identify weak states for either intervention and stuff like that. So of course there's a parallel, but there's a problem I see with too much of parallelism, because some of these some of the parallels change with the change in time. So 19th century is very different from 20th century and then from the 21st century. So even if you see the same doctrines re-emerging and being reapplied, there still is a huge ontological change that happens. If you look at it on the ground, it's I would say very different. But of course, parallels could be drawn. So I am not against drawing of parallels.
Okay, so next question, still from the same institution, from Dharmashastra National Law University. So the question is from Aditya Nilvariat, who is a candidate of Masters of Law specializing in international law. So the question is, with the rise of skepticism in the principle of self-determination, what is the future of the fourth world approaches to international law? Is it an abstract idea, or can it become the new subaltern protagonist? So proud.
Fourth world, of course, it's a scholarly innovation, actually, just as GH&IL was also a scholarly innovation. Battle of ideas, so to speak. Yes, I think people have argued about how tribals constitute the fourth state, and the current Indian state or the states, post-colonial states, continue to treat the tribal state like in the same extractive way as was done during the colonial rule. So yes, of course, you can create an intellectual movement that focuses on tribal studies and their relationship with international law. I know some people who are doing it. So perhaps there is a possibility of fourth world approach that is less state-centric and more anthropologically rich, in other words. So if you move from law to anthropology, or let's say you move from legal history to legal anthropology, it is possible to do a fourth world approach to international law where you focus on aborigines and tribal population suffering everywhere in the world.
Thank you. So next question from Nitin Krishnan. I'm really sorry for the pronunciation. So Nitin Ramakrishnan is assistant professor of international law at the School of Ethics, Governance, Culture, and Social Systems in Chinmaya I'm really sorry, Vidyayampit at the to be University of Sanskrit and Indic traditions. So it's question about basics. So who is the people using the term princely states, how much they were given subjecthood in international law, and Nitin Ramakrishnan have seen one set of documents in the 1860s in which the phrase state of a native ruler is mentioned, and the Madras High Court has recognized their subjecthood in international law. Is it true that these states didn't like to refer themselves as princely states?
Well, I think a lot of these questions emerge because the princely states within international law is actually an understudied subject. So I still think that if some of these queries, if you wait for my paper to be finished, I'm answering these questions there actually. So I think my response would be to be a little more patient, and perhaps the answers will come out as time progresses. I'm not in a position to answer where princely states did not like to be called princely states. In fact, many princely states were proud states because they claim to have ancient origins, starting from Brahma or Krishna, all sort of kind of mythological references. So they drew strength from that. So I don't know if they did not like to be called princely states. I happen to know some of my colleagues during my school education came from princely states, and I was able to sort of see how they had a sense of having come from a particular class, etc., etc. In fact, education in India is on those lines. There are specific schools, as Parvati would know, and known for educating and the princely class actually. So I think that question is beyond the purview of my research for now. But my eventual paper will answer a lot of questions being asked.
Okay, wonderful prep. So thank you.